Hey everybody, I've got our lecture for tonight, uh, all about agreements. So it's really about, okay, we've got different agreements, also known as contracts, between different parties. And so what we really want to focus on is just generally what are these agreements about, and then specifically, what sort of things do you need to be concerned about, what sort of provisions are included in these, and just some of the requirements of the contract so that you guys have an understanding of that. I've got our my Chiefs gear on in honor of the draft weekend. So hope you guys have had a good weekend. We will meet at our regular time on Monday at 5:20 on April 27th. So if you guys have any questions beforehand, feel free to give me a call. You know where to find me. All right. So tonight or today, whenever you're watching this, we're going to talk about agreements with owners, okay, which is architects' agreements with owners, with building owners. And then specifically, we want to talk about owner-generated agreements, design team agreements, so agreements between the architect and the consultants, and then construction contracts. So agreements with owners. So the book starts with responding to RFPs, or requests for proposals, which we've already kind of been through. So I'm going to go fairly quickly through this. And really, what this is about is really making sure that whenever you issue a proposal, that you're also stating for the owner what the anticipated agreement form is, right? So a response to a proposal, to their request, is usually in letter form, or sometimes in like a bound statement of qualifications or something like that. It's got a lot of text and descriptions and those sorts of things in it, that you're responding to the owner's requests, right? And so it's really important in that you state or include the contract that will be executed, because ultimately it doesn't matter what you say in the agreement, it's whatever is signed into an agreement. And the standard agreement between the owner and the architect is the B101, and that's kind of the standard base for most delivery methods. In the book, it mentions consider establishing a teaming agreement, and a teaming agreement is something that is you establish between you and your consultants who are included in the proposal, that you will act as a team and respond to the RFP. That seems awfully formal to me, and I've never engaged in that. I've never heard of anybody engaging in that. So in some ways, it seems a little odd to me, really. I don't know why they recommend it. I don't know if there's something that has happened in the industry that they believe that's important, or if it's just yet another contract document that they want to sell. So key components to responding to RFPs, which we've been through, make sure that you clarify the scope, right? So that everybody knows what you and your team are going to do or not going to do. Clarify the schedule so that everybody knows what the project schedule is, either for design or when the owner needs to be in the building. Clarify your fee and the expected payment or breakdown for that fee. Clarify the project delivery method. So remember, we talked about all sorts of delivery methods, also known as, how are you going to procure the construction? What is the relationship that you anticipate between the owner and the contractor to construct the project? Clarify your consultants, and maybe that's where the C102 comes in terms of that teaming agreement. But really, typically in an RFP, I will just simply state, for structural engineering, we're including, this. For MEP, we're including this. For so-and-so, we're including this firm. And you may include their qualifications as well if they're not familiar with them. And then clarify the project budget. That's real important because you are basing your fee around a certain budget, a certain scope. And so it's important that you clarify that, because if it goes up, if the project budget increases or decreases and you're expected to comply with that, well, that's really something important to include in the proposal. So these proposals can be offers, right? And so a lot of times what I see is that, you issue a proposal to an owner, and then, that you say to accept this proposal, sign and date down here at the bottom. Well, that can very well be your agreement if you've included all of the correct information that needs to be covered. However, there's some reasons you need to be careful about considering these as agreements, and let me go through those quickly. So you may include language in your RFP, in your proposal, that unknowingly may increase the standard of care. When you're doing an RFP, it's still a sales pitch, right? You're still selling the work. And so you may end up including language that is colorful or unnecessarily descriptive in a way that you don't realize it, but it may increase your standard of care. So you have to be really careful about saying, this is my agreement, right? And so that's kind of a distinction between the proposals and the agreement. Another one is the proposals may not cover all the terms and conditions necessary. I mean, typically in a proposal, you're not going to cover things like, payment terms, net due, you won't cover probably copyrights and licenses. You won't cover, there's just all sorts of things you may not cover. So there's stuff that will be in a contract that will not be in your proposal. And then the last reason is proposals aren't court tested. Contracts are. So particularly the AIA contracts. AIA contracts are court tested, which means they have been litigated over and over. And so there is definitely ruling history based on those contracts. And so as a result, that provides some additional protections for both you as the architect and the owner. But your proposal is not court tested. It's an original work. It's an original work that is produced just for that project, for that owner. So you assume a lot of liability in having your work interpreted by a court of law, which none of us are lawyers and none of us are judges. And so for us to anticipate, speculate as to what they might rule in the future on your language is, your guess is as good as mine. So there's a lot of risk involved in doing that. Another thing to consider is oral agreements and letters of intent. As you can imagine, oral agreements are only as good as the people that make those agreements. And so, you can, there is court testing on oral agreements, and it does happen. However, it really comes up to the memory and recollection and interpretation of that recollection of each party in that agreement. So obviously oral agreements are not preferred and tremendously risky. A letter of intent can help mitigate that risk until an official proposal or agreement is established. So, you may be engaged by a client and they say, hey, look, I don't know what this project is exactly. I really want for you to just start. I want you to start looking at this. Don't know what the scope is, so you really can't do a proposal for the whole project yet. And we really can't do an agreement. So just go forward and we'll work it out as we go. Well, so in order to respond to that, you could do a letter of intent that says, look, we intend to sign a contract, a B101, and we don't know the scope or anything like that yet. And so we can proceed, and you'll pay me on these terms, and we'll get going. The problem with that is that, again, there's no, the problem with both of these is that they don't necessarily create a sense of urgency for the owner to pay the architect unless there are some sort of penalties in a letter of agreement or an oral agreement that you just feel like you can stand behind, where the owner is really obligated to pay the architect. So with both of these scenarios, it's risky. Now, there is a contract document that when you don't have a defined scope of work, that you can see. It's really simple, it's really straightforward, and you can put that in place in lieu of either an oral agreement or letter of intent. I think the point of all this is don't do oral agreements or letters of intent. There's really no need to do them. There are contract documents that will help you out instead. So there are three main types of owner-architect agreements as a generalization. The first is owner-generated. So this is a contract between an owner and an architect that is generated by your client, the owner, not by you, not by AIA. It's not an AI document. It is their own document. You will see this a lot with governmental and institutional clients. One, because both of those entities will perform a lot of their own work. In terms of municipalities, they often see procurement of architectural and engineering services the same way. They approach it the same way that they buy floor cleaning solution for their maintenance department. And so a lot of times the language that's in there is not pertinent to providing professional services, or it's needlessly complicated, or most importantly, it transfers a tremendous amount of risk to the architect unnecessarily. And so that's one of the things that we will talk about here in just a second and dive in deeper to some of the traps of owner-generated agreements. Another type of agreement is from other professional organizations other than the AIA. The preeminent example of that is consensus docs. And I think we talked about this in a previous lecture back before the virus. And on consensus docs, that is a set of contract documents for construction that is developed by the AGC, or the Association of General Contractors. So the AGC developed a set of contract documents for two reasons. One is they wanted a set of documents that was more that benefits the owner and the contractor more than the architect. So it shifted a lot of the responsibilities from the contractor to either the owner or to the architect. So obviously there was some self-service in preparing those. The second reason is that the AGC recognizes that there is a tremendous amount of money involved with the AIA documents, any documents in the construction industry. Every time somebody prepares an AIA document, you have to pay for that. It's basically like a licensing agreement, right? That to use that document, and so it costs money. And the AIA candidly makes a lot of money off of AIA contract documents. And the third type of owner-architect agreements are, of course, the AIA documents. Those are the documents that are the preeminent document in the industry. They have all been court tested. They have all been coordinated among each other, so that whenever you use the family of documents on a project, all of the language and responsibilities are coordinated among them. And so there's tremendous value in using the AIA family of documents. Additionally, it's good to use those because it is probably the most fair in terms of distribution of liability and distribution of responsibility. So it's and probably the most clear. And again, they're court tested. So let's dive into owner-generated agreements. So some key concerns with owner-generated agreements. The first one is indemnities. So an indemnity are basically hold harmless provisions in which one party, typically in this instance, the architect, assumes the liability for another party, in this instance, the owner, in the event of a loss. So that means that you assume additional risk by indemnifying the owner. And so if you do that, that means you are assuming additional risk. In some cases, that's okay. In most cases, though, that is a non-insurable activity depending on the scope of that. And by non-insurable, what I mean is that your professional liability insurance carrier has certain terms and conditions for what they will and will not cover. And if they don't cover it, then that liability, if you indemnify your owner, falls onto you personally or the firm personally. And so there's a tremendous amount of risk in that. So some key considerations when looking at additional indemnity clauses within your contract are fourfold. What type of event will trigger the indemnification obligation? So, is it some sort of error, or is it negligence? Do you have to prove negligence? Is it anything that the owner, chooses? That has to be well defined in terms of what will trigger that. The second point is, who is the owner asking the architect to indemnify? I have seen indemnity clauses that, basically you indemnify the whole United States of America against lawsuits because they're asking for it. It may include, not just the company, but all its shareholders, board of directors, any employee, any of its subcontractors or material suppliers. The list goes on, and it could be, and that carries to stuff way outside of this project that you're working on. So you have to be really clear on who they are asking to indemnify. The third thing is, does the indemnity clause include a duty to defend? And so a lot of times they'll say that the architect agrees to indemnify and defend the owner. So what that means by defense is that if something were to happen, not only do you take on that responsibility, but you will also pay their legal fees to defend them as well. So I can't think of a single case where you would want to willingly take that on. If you did take on that additional risk, man, I would raise my fee because it's just unnecessary liability. And then is the owner asking, the last item is the owner asking the architect to indemnify the owner against its own negligent acts. And you would never want to do that because you can't control anybody else. You can only control you and your firm's actions. But you cannot control your owner. You cannot control them to be whether they're negligent or not. So if they were to do something negligent and it had an effect on the project, that there was a loss or damage, and they want you to cover that as well, don't do it. Some other risks to consider are consequential damages. So there will be contracts that will want you to cover consequential damages. Consequential damages are losses that arise out of the negligence from the architect. So, we worked through that negligence example on the, the toilet paper dispensers or whatever in the finish, or the doors, right? Well, what if that, what if that was a building where you had to replace out those doors, right? And as a result of that, let's say it's a hotel, and so you're replacing out all the guest room doors because it's wrong. If there were consequential damages, that means you also are responsible for their loss of revenue while those rooms can't be rented. And so all the things that are consequences of that negligence. You have to be careful about the language in an owner-generated contract that raises the standard of care. I mean, we've talked about that over and over, but anything that raises the standard of care above what you should expect or what is legally required in the authority having jurisdiction is simply just taking on additional risk. And another risk is ownership of the documents. A lot of times on these owner-generated documents, they want to own the drawings and the specifications as a result. That is not how the copyright laws work. That is not how the traditional agreements work. If they require that, it's important that they also indemnify you as the architect should they reuse this on a different project, or if they should fire you or you leave the project and they transfer the project to another architect of record. Why? Because what if you designed a building and then they built it and they own the documents and they say, I want to build another one just like it. So they take your documents, don't consult you, they just go do it. They just go build another building just like that. But somebody during the construction of that second project tragically dies as a result of the construction. That you are now going to be pulled into a lawsuit for a project that you weren't involved in, you weren't being compensated for, you had no knowledge of what's going on. So if you don't have them indemnify you for damages for reuse, you're opening yourself up for a world of hurt. The other thing to watch out is changes in an owner-generated agreement. Some other changes to be concerned about in terms of the standard basic services provisions are any changes to time and scheduling that you would normally anticipate to see, any changes in cost estimating provisions. I've had to, there's one municipality I've worked for that their agreements require that if the project is bid and it comes in over the budget for the project or your estimate for the project, they require you to rebid until you get it within your estimate or within their budget. I mean, my goodness, you have no control over the market, and the market changes daily. So it would be really difficult it is very difficult to get in that. You just end up just keep rebidding the project until you get it in, and it's sometimes a real challenge. You have to be careful about submittal review, making sure you don't take on any additional liability there. There may be changes to the payment provisions in terms of net interest or due dates or payment schedule. Lenders requirements. Well, sometimes there's a project, and of course, not every entity has all the cash sitting there on hand in order to build the project. And so they engage a lender to lend them money. Well, that lender is now part of the project, and they may have requirements. And those requirements may extend to you as the architect as things that you need to do, or worse, be responsible for, or have to certify. And so you need to make sure that those are not included in there, or that if they are, they're something that you're comfortable with providing. You want to carefully look at the consent to assignment. So consent to assignment is when either party, whether it's the architect or the owner, can assign the agreement, the contract, to another entity. Why would you do that? Well, if a company, if let's say an architectural firm gets bought, and now that contract is transferred over to the new company, or that owner, you are doing a project for this manufacturer who gets bought by another manufacturer, they will want to assign that contract to the new company. And normally the consent is that you can assign it to anybody else as long as the other party agrees in writing. Simple. That's in the AIA documents. They may include provisions to waive your consent necessary in order to reassign the contract on their end. So be careful about that, because they could sell their company and assign to somebody that you don't want to work with, or whatever the situation is. You need to make sure that they don't require you to do any certifications that you wouldn't normally do. Again, raising your standard of care. There may be confidentiality provisions, which with some clients is not so unusual. They may require you not to publish any information about it, or take pictures, or you may have to have additional security requirements to gain access to the job site, those sorts of things. Non-recourse provisions. So non-recourse provisions are provisions that disallow you from filing any litigation to entities or parties beyond whom you're contracted with. Here's an example of this. So let's say you've got a client that is, let's say it's 2 or 3 different people, right? 2 or 3 different businesses. And they come together and they create a shell company, an LLC or something, and that LLC is developing the project. So the non-recourse provision is that you can only file litigation against that LLC that you're contracted with. So what that means is that, and additionally, most of the time those shell companies or LLCs are set up with very little assets, only the assets related to the building. So if you had to file a lawsuit, or if anybody had to file a lawsuit that's under this contract, and they wanted to seek damages, well, they could only seek damages that are within that LLC. They could not go any further and sue the people that own that company or the companies that own that company. And so basically you end up at a dead end really quickly. So you have to be careful about non-recourse provisions. And then insurance provisions. There may be some onerous insurance provisions that they will require you to comply with. Probably the main one I see is the additional insured versus additional named insured. So additional insured is pretty typical. And what that means is that your insurer says, yes, that this owner is insured, under the normal circumstances of the contract. whether it's through your professional liability or your general liability insurance. Additional named insured means that that there is a policy sheet in which that owner is listed on the insurance. That means what that allows that owner to do is to file a claim on your insurance without ever even contacting you, because they are named on the insurance. That's very risky, and most E&O insurers will not cover that. So what that does is it takes it where they can file a claim on the insurance company will be drug into litigation. They won't assume any responsibility, so the only place left to go is your pocketbook. And so you have to be careful about any additional named insured provisions. Another one that the book mentions is consultant insurance limits, that requiring your consultants to have the same insurance limits that you do. And honestly, I can see where if you're using maybe smaller consultants or whatever, that you would want those provisions in there. But most of the time, we require our consultants to carry the same insurance coverage that we do that's required for the project. And then the last kind of thing you want to be wary of under insurance provisions is the maintenance of the E&O insurance. So they may say that you have to maintain those limits for a period of time after substantial completion. Let's say there's $4 million limit that they require for the project, and if there's a maintenance provision in there, they may require you to keep that for 10 years after that. Well, what if your business shrinks, or what if you sell the business, or what if the firm goes out of business? Well, you are still contractually obligated to maintain that same level of E&O insurance for that project for 10 years. You just don't want to agree to provisions like that. Some other considerations that you want to make sure that you look at in owner-generated agreements is making sure that you don't take responsibility for construction means and methods. Architects are not responsible for that. That's the contractor's deal. As soon as you get involved in means and methods, you take on a tremendous amount of liability. Next thing is hazardous materials. You do not want any responsibility for hazardous materials, and you don't want any language in there that somehow makes you responsible for hazardous materials, whether it's identification, removal, whatever. There could be revisions to termination or suspension of services. Most contracts include the provisions on how you undo the contract should one of the parties want to undo it. You'll need to check and make sure that the termination and suspension of services is something equitable that you can live with. And then another consideration is owner-provided information. So whether it's the program or their geotechnical report or their survey that they provide, or whatever information it is that they provide, you want the provision in there that states that that you can rely on the accuracy and completeness of that information that they provide you, and that you accept no responsibility for that. Yeah, it's just one of those things that you've got to have, because you've got whatever they give you, you have to assume is right. You're not there to be the compliance officer for everything that your owner generates. All right. So project design team agreements. So these are the agreements between you and your consultants. And the book covers three things. These teaming agreements again. Basic services agreement, so the agreement to do the design for the project in question. And then also joint ventures. So again, teaming agreements, I'm not going to go into. I've never seen it. I don't see it. I don't know why they even bring it up in the book. Maybe it's because they've got another contract to sell. I don't know. All right, so considerations for basic services agreement. So most of the time, the agreement between you and your consultant is going to be a C401. And some things you want to think about are Compliance with the prime agreement. So the prime agreement is the agreement between you and the owner. And it's the prime, it's the first, right? Anything below that are subcontracts. So you want to make sure that whatever you put in their agreement corresponds with what's the requirement in the prime agreement. Most of the time, I take the C401 and on all of the requirements, I say refer to Exhibit A, refer to Exhibit A, refer to Exhibit A. And Exhibit A is my agreement, the prime agreement. That way, I know for sure that my consultant has to fulfill the same requirements that I do for the project. You need to make sure that the contract defines the responsibilities and compensation. So the responsibility of your subcontractor, your consultant, and their compensation. And then establishing any digital practice protocols. Digital practice protocols are the agreement, and again, there's an AIA contract for this that just says, hey, we're going to freely transfer electronic information to you, whether it's my model or CAD drawings or printed material or whatever it is. You're free to use it, but know that you have to do your own work. You're responsible for that. You can't come back and say later, hey, the reason the consultant drawings were screwed up was because the architect's model didn't show this or whatever. So, again, our deliverables are still two-dimensional printed drawings. So it really is just a way to reduce liability. And so there will be some sort of CAD user agreement in your office that you'll have. Some considerations for owner retained consultants. On bigger projects, there will be consultants that are working on the project that are not your consultants. Okay. And so you want to make sure that when they are securing agreements with these consultants, when you want to make sure your owner, when they are engaging these consultants that are not your consultants, that they do some things. One, make sure you look for gaps and overlaps of services. Make sure that the services they are providing are ones that nobody else on your team are doing, and where one team member ends and the other team member picks up. So some examples of that might be like a kitchen equipment supplier. Oftentimes the kitchen equipment supplier is contracted directly with the owner, and the kitchen equipment supplier is preparing drawings and taking direction directly from the owner. However, it's obviously an integral part of your project, and so you have to coordinate with them, and you need to make sure that you know what they're providing and where their information stops and where your MEP engineer needs to pick up in terms of the connections and the plumbing and the wiring and the HVAC to all the kitchen equipment, and then who does the connections, and what all that looks like. That's one example. The next thing is you want to define the coordination and communication among the design team. So, obviously if it's their consultant, you can't direct them to do certain things. However, you are going to be expected to coordinate and communicate with them. And so what does that look like? Does it need to go through the owner? Can I communicate with them directly? What does that look like? Next thing is you want to clarify liability and indemnification from owner-related consultants. Make sure that somehow they haven't, their subconsultant hasn't somehow pushed liability or anything onto you as the architect. And then again, establish a digital practice protocol. Make sure that there's something in writing so that we all have an agreement, what it looks like when we share electronic information. Now, joint ventures, it is typically a separate legal entity, and it can be a legal entity that's defined by AIA document C101. And so some things to think about whenever you're doing this is, what is the overall management of the joint venture? What are the financial arrangements? So once the joint venture receives money, how is it divided? And is it based on profit loss? Is it based on the individual scopes of work by each of the parties? What does that look like? What does the insurance provisions look like? Who's providing it? Are both providing it? If there were a claim, how does that get divided among the insurers? Those sorts of things. And again, your digital practice protocols for the joint venture members. All right, construction contracts. So whenever you're preparing a construction contract, you have to know your delivery method, just like we talked about. Is it design, bid, build? Is it CM as advisor, CM constructor, design, build? How is this being delivered? Because each of these have a separate contract type. So when we look at the parts of the construction contract, you've seen this before. You've seen this diagram, right? So these are all the parts of the project, but really the contract documents are here. So the contract documents include the agreement, the actual written contract that looks very similar to yours with the owner, but it also includes the performance bond, the payment bond, and any insurance certificates. It includes the general conditions and supplemental general conditions. It includes the specifications, the drawings, the addenda, and any contract modification documents issued after the contract is signed. So those are the contract documents. So unlike you as the architect, where you just have 18-page, 8.5 by 11 contract, the contractor's contract includes all of these other things in addition to that document. And again, those supplemental contract documents, this is not a new slide, you've seen this before. Supplemental instructions, proposal request, contract change directives, and of course, change orders. The contract with the contractor will also include the basis for payment. Typical bases for payment include the stipulated sum, which we've talked about, a cost plus fee. So that's the cost of the subcontracts plus a fee, which is usually a percentage on top of that. A guaranteed maximum price, or GMP, and sometimes unit prices. Very rarely on vertical construction that we're involved with, but it is extremely common on public works type projects that include horizontal construction. So for instance, when somebody is bidding a new roadway, they will bid it by unit price. And they'll say, look, the cost is, $1,500 per foot of road. And so they go out there and they start building roads, and they measure how many linear feet they did, and that's the contract amount. So yeah, those are typical bases of payment for the general contractor. That contract will also include other provisions, the scope of the project, which is typically defined by the specifications and the drawings, the date of commencement, in other words, the date that the contractor starts, the contract sum, whatever that might be from the previous slide, progress payments, in other words, how do you pay the contractor, and what the date and receipt of the payment of the contractor is for each month, and then how long the architect has to review it, and then when the owner has to pay that progress payment. Typically includes requirements of schedule of values. So the schedule of values is the value of each of the line items of work. Typically it's done by subcontract, but not always. So they may take all of sometimes I've seen it by division, which gets tremendously confusing. Sometimes they might do it by different scopes of work or structural systems or things of that nature. It's typically best if it's done by contract, subcontract. It will include retainage requirements. And so we talked about retainage in that typically what you'll see is that the owner will pay 90% of the progress payment that's due, and the additional 10% is held by the owner as retainage until the end of the project. And so that becomes the money at the end of the project that ensures the contractor will complete. It will typically include the substantial completion dates and requirements, as well as the final completion dates and requirements, along with the final payment. It'll include warranty periods, dispute resolution, so if there is a dispute during the project, how that gets resolved. It will include consequential damages, which we talked about. It will also include a definition of liquidated damages. So liquidated damages is a penalty to the contractor that is in the liquid form, also known as cash. And it is damages for not completing the project at substantial completion by the date in the contract. So, a lot of times you'll see, the contractor will bid the project and the owner says, it has to be done by September 24th. Well, so September 24th comes and goes, and the contractor is, 10 days late. Well, in the contract, there would be liquidated damages for $1,500 a day, say. So then at the end of the project, there's liquidated damages that can be charged to the contractor of $15,000. $1,500 a day times 10 days. So that's $15,000. That amount gets deducted from the contract amount. And as a result, that's one of the reasons to keep retainage in case there are liquidated damages. Another contract provision in a construction contract would be a definition of any statute of limitations or repose. Although I rarely see that in construction contracts, most of the time that just really is up to the state statutes surrounding the statute of limitations or repose. So we will meet Monday, and I'll be happy to review any questions you might have, and look forward to seeing everybody. I am going to try and also put together a quiz for you guys that'll be due next week as well. I think I've got it written. I just need to get it out to you. So as always, call, email if you have questions. I'm available. Hope you're staying safe and healthy, and I'll see you Monday. Thanks, everybody. Bye.